Hello, this is Matt on the Moon Lambeau channel. There's so much going on in the SEC versus Ripple case and so much being discussed within the community that it's hard to keep up with it, but I'm going to give you a number of updates in this latest Moon Lambeau hot jam. The SEC they're seeking to hide information about about XRP holders from XRP holders, which is just a completely absurd idea. And an attorney, John Deaton, he also points out that if the original opinion from the Supreme Court of the United States in the SEC v. Howey case is taken literally, then no court could ever find XRP to be a security. And frankly, I'll say only an activist judge would ever find that XRP is a security. You know, if we're going to take the letter of the law as it is, to be as it was intended from the beginning, as originally ruled upon, you couldn't find it to be any other way, and I'll explain what I mean in stating that. And then this is an interesting one too. Attorney John Deaton also shares his opinion that SEC Supreme Leader and dictator Kim Jong-Gensler will resign from the SEC due to pressure from Congress. And I'm calling him Kim Jong-Gensler, not Attorney Deaton. But Attorney Deaton does believe, and he's predicting publicly, that Gary Gensler is going to resign from the SEC due to pressure from Congress. So plenty to talk about here. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. I'll start with this one just because it struck me in such a way that I was like, yeah, it's a good way of wording it because it really highlights the absurdity of what's going on in this particular part of this case. This comes from XRP community member Stefan Huber, and he wrote the following. He was actually talking about, to set the table a little bit, he's talking about the SEC's alleged expert. They hired a guy named Patrick Doody. We've all been talking about him in the community in recent days. Well, this Patrick Doody, hired by the SEC, he's created a report, which we've not yet seen, but this report, it speaks to the mindset of XRP holders as to why they're purchasing XRP, and undoubtedly, he's going to argue, at least in part, that the people are purchasing XRP just hoping that it's going to be worth more, and that's all that it ever has been. That's all it's been to this point, and that's important because that's a prong of the Howey test. So that's part of what we're expecting to be in this report, and the SEC's paying this Patrick Doody for his services, and they've hired him in the past in other cases, including in Telegram. And so Stefan Huber wrote the following on this. The SEC wants the court to seal the expert report about what XRP holders think from the XRP holders to protect them? Can't make this up, which I think is completely absurd, but it is the case. The SEC wants that report to be sealed. It's about XRP holders, and the XRP holders shouldn't see that. What, to protect us, right? Which is also funny because they also don't want John Deaton to have it, and it's going to be part of the case. Actually, I have a separate tweet from, I think, a little bit later in the video. I'm pretty sure, but in case I'm misremembering what I had lined up for this, Attorney Deaton had stated, you know, even if, and I'm paraphrasing here, but even if this expert report from Patrick Doody is withheld, it's ultimately going to be part of the case anyway because it has to be shared during summary judgment, if memory serves. I think that's what he said anyway. But it's completely absurd on its face, completely ridiculous. Now getting down to the rule of law. I mean, do you think that words matters? Do you think that if a precedent is set in course, a binding precedent is set in course, is it your position that the binding precedent really should be followed, or should judges just be able to change things a little bit, interpret it a little bit differently than what was literally said? Because that sounds scary as hell to me. Because if a judge can just have any interpretation that they think actually makes sense, or supposing intent from people that wrote different things, then you can come to any conclusion that you want. So basically, it's many steps away from utilizing logic. If you think that you can look at something and say, okay, but I think what they really meant is so-and-so, or just adjusted a bit, you're no longer talking about law. You're just talking about personal opinion. And so if any judge on the planet is judging in such a way, that's an activist judge. And so I don't care what the topic is, that's bad. That is not what a judge is supposed to do. They're supposed to look at exactly what the law is and then make sure that it's sufficiently enforced. Not to interpret and think, well, I think they might have met something. No, you don't get to do that. Now, attorney John Deaton, speaking on this idea, shared the following. And this is important because this is what it matters for all XRP holders. It plays directly into the SEC versus Ripple case. He wrote, today's Supreme Court is conservative. At least half are described as strict constructionists. They strictly adhere to the plain language of the law. Would they strictly construe and apply the courts solely, the term solely, on the efforts of others prong of the Howey test? And so what's he talking about here? Well, there are 4 prongs of the Howey test. One of them is that the investors who invest their money, they're expecting profits solely on the efforts of others. Again, it has to be solely on the efforts of others. That's how it's written. And so I pulled up what's on your screen right now. This is from 1946. This is the original opinion from the court, from the Supreme Court, from Justice Frank Murray. He wrote what's on your screen in 1946. 1946. And part of what he wrote, and this is where the prongs come from. Look at this. It was shared, it was at least twice. I just did Control F search for the word solely. And what do you know? It popped up right here. And I pulled up this from Court Listener, but there are all sorts of copies of this all over the internet. So you can find it for yourself too. But look at what was written here. Here, I can start using this. This definition was uniformly applied by state courts to a variety of situations where individuals were led to invest money in a common enterprise with the expectation that they would earn a profit solely through the efforts of the promoter or of some one other than themselves. Solely through the efforts of the promoter or of someone other than themselves. Well, do words matter? Should we just be able to say, well, he said solely, but he didn't really mean solely? Does that make logical sense? You shouldn't be able to do that, right? He said solely, but should an activist judge be able to come in and say, he didn't really mean solely. We'll apply it. Wait, just take out that word solely. That part's inconvenient for what we think makes sense and we're not going to apply. Is that fair? No, that's not how law works. That's no longer law if that's your position, okay? So when they say solely through the efforts of others, that's why this is so important. The idea of not just why are people investing? Well, what's actually moving the price of XRP? And it's provably the case, as Ripple is going to argue, they are arguing, that XRP, it's just moving in line with the rest of the market. It's following Bitcoin. And that's provably true. That's why this is crucial. So if you're literally taking this, as you should, because this is law, this is what should be considered. Should it not? Right? And so then that was retweeted, what I just shared with you, because John Deaton, again, he's just saying, well, this is what the court ruling was back in 1946. That was the opinion of the Supreme Court in 1946. The word solely is in there, and John Deaton's pointing that out. So he's asking, would the current Supreme Court justices, would they strictly construe the courts solely on the efforts of other prong of the Howey test? How would they perceive that? Like, as it's written? Or would they just do whatever the hell they want with it? What would they think? And so J.W. Verrett retweeted that. Now, J.W. Verrett, he was formerly an SEC advisor. And I've highlighted some of the stuff that he said on my channel in the past. And he seems to be thinking in line with what Attorney Deaton's thinking. And here's what J.W. Verrett wrote. He said, my favorite Howey argument, John Deaton. Solely now means something like mostly. It would take years, but better than ever chance SCOTUS, Supreme Court of the United States, would pull it back toward original meaning. So again, there's original meaning as written by the court in 1946, and then there's how it's being applied now. And so that's why he said solely now means something like mostly. That's the problem. If you can do that, then law no longer matters. If you can say solely now means mostly, law doesn't matter. And that's why that concept burns my biscuits. I don't like people and putting their own thoughts and ideology into the rule of law. I'm not a fan of that. And then there was also this from Attorney John Deaton. He retweeted something from Frank Chaparro, and who is the editor-at-large at The Block. I highlight their sources from time to time. And Frank Chaparro wrote, Citadel's Ken Griffin brutally chastises SEC Chair Gary Gensler, and he said, I quote, I would love to see Gary Gensler pivot from talking about regulating cryptocurrency to actually providing regulatory clarity, end quote. Wouldn't we all love to see that? So Attorney Deaton retweeted that and wrote, I've said it before, that Gary Gensler will resign after the midterms, and when he starts getting called to the Hill by Patrick McHenry and the Senate to answer questions. But he will try to severely wound crypto. That'd be interesting. That would be interesting to see if he actually resigns as a result of the possible change in power in Congress come this November in the United States. Because it's supposed by many people on the right and also a lot of people on the left, based on the current state of the economy and all sorts of other things, and polling also, that looks like there might be a shift in power in the United States. And so I'm not here to preach politics. I'm just stating things that are being pontificated currently, just for the sake of making sure that the table's sufficiently set as I'm describing this stuff. But if that happens, and there are a lot of people supposing that that's the most likely thing by quite a bit actually, if that happens, John Deaton's saying that his prediction, he thinks that Gary Gensler is actually going to go the way of the dodo, my favorite extinct avian creature. He thinks that he's actually going to resign. It does make you wonder, so if that happens, who's taking over? Can we get Jay Clayton back? At this point, I will take Jay Clayton back, and he's just a despicable human. I will pick Jay Clayton over Gary Gensler. That's how bad Gary Gensler is right now. My God. Because and the reason I say that, fine, Jay Clayton, he's the one that harmed the XRP holders in the first place, but Gary Gensler, he's taken a much more draconian approach in ripping to shreds the entire cryptocurrency asset class in the United States. That's the reason that I say that. It is what it is. Let me know what you think before. There's a lot of opinion in this video. And so that's what I think, and I love diversity of thought. So if you think I'm nailing it, let me know. If you think I'm way off base, you can let me know that too. Again, I really, truly value diversity of thought. So let me know what you think and keep the conversation going in the comment section below. But I'm going to go ahead and wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.